With that, may I welcome Judith Mackinnon, Head of People Advice at the Scottish Government. The committee has agreed that while members can see Ms Mackinnon, her evidence will be broadcast in audio only. And I begin by inviting Ms Mackinnon to take the oath. Ms Mackinnon, would you please raise your right hand and repeat after me? I swear by Almighty God.
I swear by Almighty God.
That I will tell the truth, the whole truth, and nothing but the truth.
That I will tell the truth, the whole truth, and nothing but the truth.
Thank you, Ms Mackinnon. May I invite you to make an opening statement, please?
Thank you, Convener. My opening statement aims to set out my role and responsibilities as the investigating officer into the harassment complaints raised against former First Minister. As explained at my previous attendance before committee, I am a CIPD qualified HR professional with considerable experience in carrying out and advising on workplace investigations and instructing employment tribunals. I've been the Head of People Advice since August 2017 when I joined the Scottish Government. In response to the Permanent Secretary's staff message at the beginning of November 2017, which was intended to raise awareness and tackle the issue of sexual harassment at work, a number of channels were put in place to enable people to come forward. A number of people did come forward over the following months to share their experience of harassment in the workplace, some about civil servants and some about the former minister. I took a person-centred approach with the aim of understanding the experience and respecting the wishes of those individuals, including access to a formal process where required in line with our duty of care. Two people decided they wanted to make formal complaints under the harassment procedure about a former minister in January 2018, and again in line with our duty of care, a formal investigation commenced. As the appointed IO, I was responsible for undertaking an impartial collection of facts from complainers and from witnesses that arose from the complainers' accounts and those identified by the former First Minister. Provided regular update information to complainers on the progress of the investigation and produced interim and final reports for the Permanent Secretary to consider in her decision-making capacity. As has been set out previously, I'm giving evidence to the committee on behalf of ministers and not in a personal capacity. The committee will be aware that there is an undertaking given to the Court of Session which applies to my investigation reports and other documents created or given to me during my investigation. I must comply with that undertaking, as to breach it could constitute contempt of court. There is also a disagreement between the Scottish Government and Mr Salmon's legal representatives regarding the decision report. I am advised that while that disagreement remains, there may be certain questions about the decision report which I cannot answer. Do so may amount to contempt of court. If I am concerned that I may breach the undertaking or risk at any point identifying the complainers, then I will have to decline to answer at this time and come back to you in writing so that the impact of the contempt of court order can be considered fully. I will also do that to ensure accuracy on detailed matters. And finally, Convener, I remain a member of the FDA Trade Union.
Thank you very much, Ms Mackinnon, and we'll go straight to questions from our committee members. First of all, Margaret Mitchell.
Thank you, Convener. Good morning, Ms Mackinnon. Under our first theme, the process and support to raise a concern, can you explain how the Scottish Government could accept an indication of an individual wishing to make a formal complaint in mid-December for a policy which was not agreed until 20th of December?
Sorry, can I just clarify your question?
How you could accept an indication from an individual that they wanted to make a formal complaint and that to be indicated in mid-December and accepted for a policy that wasn't agreed until the 20th of December.
It's true to say that one of the complainers indicated, I think on the 19th of December, that she would likely make a formal complaint, but that she still had some questions that she wanted clarified. And at that point, you're correct that the policy was not signed off. The policy was signed off the following day, the 20th of December, and I had provided the complainer with a response to her queries that she had submitted on the 19th of December. And so at that point, she still might not have actually made a formal complaint. It was an indication only.
And you provided that additional information when?
On the 19th of December.
Right, so that was all considered. Can I ask therefore whether the individual wishing to move to the complaints phase was told to wait until January 2018 to make formal complaints so that it or any other complainant could be dealt with under the procedure?
I think what we said to her was, or what I said to her was that we would speak again in January. So at that point, it was still an indication, and it was for her to decide finally what she wanted to do, which she did in January.
You appreciate this all appears rather convenient. Perhaps if I could move on to your last appearance before the committee, and you confirmed then that you had contacted Police Scotland to seek advice on handling cases of sexual harassment, and that several officers had come to meet with you in December 2017. I asked you who you had contacted, and you wrote to the committee following your appearance to confirm that Gillian Russell had provided you with a contact in the Public Protection Specialist Crime Unit. In your written evidence, you describe this December 2017 meeting as a generic meeting about person-centred approach, a person-centred approach that did not include reference to any specific concerns, complaints or individuals. So can you expand a bit more about that meeting? For example, who else was present at this meeting?
So there was myself from Scottish Government, and I think there were 3 officers from Police Scotland in the meeting. And we were...
Carry on? Yeah. And no one else was present?
Sorry. No.
No, thank you. And how did the information you received from the police inform HR's approach and that of the informal confidant?
Very much from that person-centred perspective, though it was about being open to someone who comes forward, not to be judgmental, to be able to listen to them, to understand their concerns, to understand why they had come forward, to start to understand what they would like to do, if anything, and very much be kind of directed by the individual, very person-centred approach.
Okay, and I think you indicated before with the generic meeting that if we wanted to know who was there from Police Scotland, we'd have to contact them directly. Was that correct? You're not able to say?
Yes.
Okay.
No.
Moving on now, during the course of the investigation, were you involved in discussions on the referral to the police?
So, at the end of July 2018, after I had submitted the final IO report to the Permanent Secretary, who was the decision maker, I was asked to sound out how the complainers felt about the Scottish Government potentially reporting the matter to the police. So I did that, and I spoke to both complainers, and they had some questions. mainly about what the next steps would be, what a police process might entail, what would be expected of them, etc. So I contacted one of those officers who I'd met previously, and again, it wasn't case specific, but I was asking her to help me be able to feed back to those individuals about what they could expect as part of a police process.
Right. And you're not able to say who that police officer was, are you?
No.
No, okay. And can you give an approximate date such discussions took place, and were any other senior officers or officials involved when you had these soundings and you talked to the complainants in the way you've described?
No, it was just myself. I had a telephone call with one of them, and I met with one of them, and then we had some follow-up email correspondence.
Right, and the referral wasn't considered till a little bit later then. Should it have been considered at the point the concern was raised?
Do you mean the initial formal complaint coming in?
Yeah.
At that stage?
Yeah.
I'm not aware that it was considered. I think that we were very much in the fact-finding stage of the situation. And I don't remember an actual conversation once the complaints came in about reporting at that stage to the police.
Okay, but it was part of the route map, wasn't it? An option was to report to the police.
Yes, I believe so.
So that must have formed part of the thinking and discussions as the process was developed, and certainly when the complaints were received and the investigation took place.
I think that once the fact gathering had been done and the full picture was known, I think at that stage, and that was when the Permanent Secretary is the deciding officer to consider the appropriateness of referring it to the police.
Okay, thank you.
I have a supplementary in this issue from Maureen Watt.
Thank you, Convener. Good morning, Ms Mackinnon. You said that the Scottish Government reported the matter to the police. Do you think that's appropriate? Don't you think as an employer you should have said to your employee, oh, you must go to the police and report it yourselves? A third party reporting a matter to the police seems a bit odd.
The procedure allows for both, actually. So, and very clearly set out in the procedure that individuals at any time could go to the police if they wanted to. And similarly, it states that the Scottish Government may, at some point, decide that a referral was appropriate. So the procedure allows for both of those things.
Don't you think that it looks pretty bad, as if the Scottish Government are kind of encouraging the complainant to go to the police rather than them making up their own mind?
Well, as I said, the decision for Scottish Government to make in relation to that was clearly set out, and one of the reasons for myself speaking to the complainers to test out their views about potentially reporting it to the police was for their views to be taken into account as part of that consideration. I have to say I wasn't, just shortly after I started those conversations with the complainers, I handed over to Nicky Richards a continuation of that discussion because I went on leave and I was overseas. So I started the conversation, and I think my understanding is that continued, and their concerns were responded to after I went on leave.
Okay, thank you, Convener. I'm sure others will pick it up.
Yeah, I have a question before I move on to Murdo Fraser on the same issue. Can I ask Ms Mackinnon, you used the expression that you were asked to sound out the complainers about reporting to the police. Who was it that asked you to sound them out?
That would more than likely be Nicky Richards.
Okay, thank you. Murdo Fraser.
Thank you. Thank you, Convener. Good morning. Ms Mackinnon, just to follow up on this line of questioning from other colleagues, would it be fair to say the complainants were reluctant themselves to report to the police?
I think you could say that. I don't think it had been their intention when they initially had come forward to do that.
So would it be fair to say the matter would not have gone to the police had yourself and the Scottish Government not taken it to the police? The complainants would not have done that off their own bat?
I can't say that for sure.
Okay. Okay, thank you.
Alistair Allen.
Thank you, Convener. Ms Mackinnon, as you're more than aware, in the end the case was conceded around issues around perceived bias and the involvement at multiple stages of the same individuals. To your knowledge, did anyone raise concerns about the fact that you had already been involved in creating the procedure and you were now going to be investigating officer and implementing that procedure?
No. I think I responded to this in my previous attendance at committee. I think those of us who were involved had aware and knowledge about my prior contact, which was limited and administrative. Those involved also had the same approach and interpretation of paragraph 10, which was that the IO would not be involved in the matters being complained of. And so that awareness from the outset that I had had that prior contact was not raised as an issue at any point during the process.
Thank you. And how many people were involved in appointing you to that role of investigating officer? I'm not asking you to name people who are not senior civil servant level, but who appointed you to that role?
So Nicky Richards, who was my line manager and the director of people, appointed me to the IO role.
And I think this may have been a question I've asked you or others in the past, but even putting to one side the whole content of the policies that we're talking about, very important as those are, in terms of common sense, did it occur to you at any stage that this was an odd situation to be involved at multiple stages of the process?
Not from a standard HR perspective, no. It felt relatively straightforward.
Okay, thank you, Convener.
Yes. When you became the investigating officer, were you consulted at all by anyone from the Scottish Government Legal Directorate to make sure, or did you consult anybody from the Legal Directorate to make sure that there wasn't any reason why you shouldn't take on this role, given its importance and the potential legal repercussions if the appointment wasn't in line with the requirements? No, I don't recall a specific discussion around the appropriateness of my appointment. As I said, those of us who were involved were very aware of our interpretation of the procedure, the policy statement, and the awareness of my prior contact. Nobody raised a concern about that, and they knew about it. Everyone knew about it before I was appointed as the IO. So when did the concern about that it wasn't a particularly good idea and that may cause problems, when did that become apparent, and who did it become apparent to? To
my understanding, it became apparent during October 2018 as part of the judicial review process. And I think my understanding is that it was Scottish Government's counsel who hadn't been aware of the prior contact who had raised it.
And before that, there was no hint from anybody that they thought that it wasn't the brightest of ideas?
No.
Okay, thank you.
Alex Cole-Hamilton.
Thank you very much, Convener. I have one small supplemental to Margaret Mitchell's line of questioning and then move into some more detailed issues of my own. Margaret Mitchell asked you... Oh, good morning, Judith Mackinnon. Ms Mackinnon, Margaret Mitchell asked you about the timeline of the first disclosure from the complainers to the introduction of the policy on the 20th of December. Can I just ask, had the complainer insisted on making a formal complaint in early November when this first came to light, how would that have been handled in the absence of a policy covering former ministers?
If someone raises a complaint, we have a duty of care to investigate it. And whether we have a policy in place or not, then we are obligated to investigate it. It would have made life quite difficult not to have a procedure in place, but we would still have been obligated to do so.
Okay, and was there any suggestion at the time when this person or persons came forward that they hold back, saying there is a policy coming that will suit your complaint, can you just hang fire?
No.
Okay.
Not as far as I know, certainly not from myself.
Okay, just move into a different line of questioning here. Just going back to November 2017, there was a lot going on. There was the Me Too movement, there was the Mark MacDonald resignation. We also understand now, or through the deliberations of the committee, that at that time, senior members of the government were being made aware about allegations made against Alex Salmond in Edinburgh Airport. Can I just ask, in terms of background and what was going on while this policy was developed and those complainers were starting to come forward, when you first learned of the particular allegations against Mr Salmond from the airport? I
didn't know and still don't know what the particular allegations against Mr Salmond were about the airport.
I'm sorry, I'll rephrase, not the detail, but when did you first learn there were allegations coming from the airport, irrespective of whether you were cited on the detail?
So my involvement was limited to staff welfare rather than what was being raised. So my understanding was that the former First Minister and or his lawyers had been contacting Scottish Government staff, and they had raised that with their line managers. And I was asked to contact the lawyers and just simply ask if they wished to speak to any Scottish Government staff, if they could direct that through myself.
And can you give us an approximate...
And that was all.
Can you give us an approximate date for that? Is it early November, late November? So, I'm sorry.
Early November.
Early November. Okay, thank you. Going back to early November, can you remind us how it was that first meeting that you had with Miss A? How did that come about? I mean, did she approach you? Was it through an intermediary? Or did you understand that she had something to say and sought her out?
So my first awareness of Miss E was on the 22nd of November. And my understanding was that she had met with Gillian Russell and Barbara Allison. And in Gillian's role as this confidential sounding board. And after that meeting, Gillian notified myself and Nikki Richards of the meeting, in the name of the individual anonymous. And we agreed that she would suggest to the person that she could have a conversation with someone from HR if she wished to. And Gillian did that, and then I think the individual got in touch with Nikki directly, and Nikki we set up a meeting for the 5th of December, and that was the first time that I had met the individual. So that was my understanding of the sequence of events to my first meeting the individual.
So can you just confirm, you said the 5th of December, our papers suggest it was earlier in November that meeting took place and is referred to in document XX047 in the first week of November 2017 that is when Nicola Richards and yourself first met Miss A?
No, it was December.
Okay, that might just
December 2017, definitely.
That might just be an error in our papers. Thank you for that. So when did you first become aware that you would likely become the investigating officer?
So Nikki and I had been having discussions in early December about that. And I think, as I'd said previously, that there was felt to be 4 conditions required for an appropriate investigating officer. They had to be senior enough, have some experience in looking into matters like this. Had to be someone who was unconnected to any of the individuals who might be raising issues, and have no involvement in the matters that were being complained of. We were trying to keep the number of individuals limited who were involved, and also there had to be an ability to make the time to be able to carry out the investigation. So on that basis, Nikki had suggested that I would be, it would be myself, most likely that would be the IO.
So it was contemporaneous with that first meeting in early December, around that time, early December 2017.
Yeah, early December, yeah.
So on the 6th of December 2017, you received an email from Nicola Richards, which is referenced in document in our papers XX047, in which Nicola Richards specifically asks you to look at the timeline, and there's a range of sort of events that took place around that month of November and early December, and suggested it might need, quote unquote, testing back against the policy. Can I just ask what you understood that to mean?
I don't have that document in front of me, and I think I would like to refer to it before I respond, if you don't mind.
Okay, I mean, I can just read you. It's not a long email. I will read you the email. It just said, "Hi there, I've updated the timeline, and this is the final version of the policy I've sent to PermSec. Do you want to have a look at the timeline and see what you think? It might need testing back against the policy."
I can't recall off the top of my head. Sorry, okay. I'll have to get back to you on that point.
That's absolutely fine. I've just a couple more questions, Convener, if I may. This is fast forwarding to when Mr. Salmond was first told about the government investigation. And the Permanent Secretary wrote to Mr. Salmond on the 7th of March 2018. In that letter, it invited him to suggest witnesses to be contacted and his version of events to be set out. And you were appointed, as I understand, the sort of recipient or the intermediary to whom he should correspond. Did he make any such recommendations or contact you with a list of questions or concerns?
The Levy and McCree, the lawyers, got in touch with me directly about witnesses and to provide details of witnesses for me to contact. And I had correspondence back and forward with them around those witnesses and the provision of written statements.
And when you received that correspondence, what was the process by which you would decide what would be shared with Mr. Salmond and what would not be? I mean, who would you discuss that with?
Shared in terms of what, sorry?
Well, you were the intermediary. You were receiving the correspondence from Levy-McRae, and obviously this was a bit of a bombshell moment for Mr. Salmond. This is suddenly a revelation that he's under investigation by the government he used to lead. There would have been quite, I would imagine, a range of suggestions or concerns or protestations. How would you handle that? Any correspondence you receive from Levy-McRae, would you take a decision yourself? Would you take it to the Permanent Secretary? Would you take it to Nicola Richards?
So I think it's important to distinguish what my interaction with Levy-McRae was. It was very much limited to the provision of witnesses, names and statements. The broader correspondence, I think that you're maybe referring to around Levy-McRae's responses to the Permanent Secretary's letter were really for between the Permanent Secretary and Levy-McRae. So the kind of back and forward and the protestations, as you say, the disagreement with the approach that was being taken, that was actually all between the Permanent Secretary and Levy-McRae. I had really quite a limited role in terms of getting from them the names of people that I could contact and then interview and engage with.
Thank you for clarifying that. So in respect of the requests or the recommendations of witnesses that Mr. Salmond would like the government to interview, did you act on all of those recommendations? Did you seek out all of those witnesses as described by him?
Yes, I interviewed, put forward 5 people, I think, and I interviewed 3 of them face-to-face. I had 1 telephone consult with 1 of them, and a 5th person provided a statement via the lawyers, and that was taken and incorporated into the report.
Okay, thank you. Final question for me, Convener, if I may. So within the Senior Civil Service or the SNP, who else knew about the complaints and the investigation, either from the start of November till the sort of public revelation of their existence in the summer? Was it a big group? Was it a small group? Can you name them?
No, I think it was, well, we certainly tried to keep it as tight as possible. And in the very early days, it was really limited to those individuals who have already been named as being involved. So, people like Nikki and myself and Gillian Russell and Barbara Allison, SGLD. So that was kept really tight as the investigation commenced. Once the Permanent Secretary had got in touch with Mr. Salmond's lawyers, and there were obviously then ongoing actions that were taking place. Again, I think it was that small group who were involved. Yeah, I think the kind of wider group was later after the decision came out and the judicial review process began. There was a kind of a wider group of people who were involved.
And to your knowledge,
included things like, sorry.
That's okay. And to your knowledge, was anybody in the high command of the SNP or in the special advisor role functions, as in chief of staff or other special advisors within the SNP, aware of the existence of the complaints or the investigations against Mr. Salmond prior to the turn of the year? So in the November-December period, when they were first forthcoming, were any of the people who are not necessarily career civil service, but either special advisors or SNP of staff themselves, aware in any way of these complaints?
Not as far as I am aware.
Okay, thank you.
Angela Constance.
Thank you very much, Convener. I've got a couple of follow-ups and then some questions of my own. Good morning, Ms Mackinnon. Ms Mackinnon, you said earlier to Margaret Mitchell and others that you knew that it was possible that individuals that you were sharing the draft procedure with, in your own words, you said were likely to make a complaint. Therefore, do you now think, with hindsight, that it was inappropriate to show them draft copies of the procedure?
I think it would have been more ideal if the procedure had been finalised, but we were clear with it was only shared with one complainer, and we were clear with her that it was still in a draft state at that point, but it was nearing its final version.
Okay. And you also said previously, Ms Mackinnon, that you thought that your contact with complainers was clearly allowed under previous drafts of the procedure. Can you confirm that you accept that for the purposes of the complaints and for the judicial review, that the only iteration that other people saw and the only interaction that actually matters is the final draft of the procedure as opposed to previous iterations?
I absolutely accept that the removal of the more detail of the previous versions of the procedure left paragraph 10 open to other interpretations. Absolutely.
I suppose what my question was, Ms Mackinnon, is that actually at the end of the day, the only draft that matters is the final draft, the draft that was approved, and that perhaps earlier iterations and what that meant or didn't mean in many regards is irrelevant.
I don't disagree with you. All I would say is that all employment policies, HR policies, are open to interpretation of how they are applied. When we go to employment tribunals as a matter of course to defend a position of dismissal or, whatever, these arguments with people who bring complaints and the Scottish Government centre around the application of policy and procedure in most cases and the different interpretation of those things. So it's not uncommon for us as an organisation to be able to have to defend our position in relation to an interpretation of a policy.
Okay, I'll move on to some other aspects, Convener. Ms Mackinnon, am I correct in understanding that your role was to gather and present information from the complainants, but your role was also to prepare and present information gathered from Mr Salmond? You had...
Yes, correct.
Okay. Again, I appreciate hindsight's a wonderful thing, but would you now consider that a conflict of interest?
Not quite sure I understand what you mean in relation to the two different sets of witnesses. Is that what you mean?
Yeah, I just think it's quite a simple question with respect, Ms Mackinnon. You had the dual role, if I can put it that way, where you had to, in an unbiased manner, collect information from those who were making complaints and present that information to the ultimate decision maker, but you were also charged with preparing and gathering information from the individual who the complaints were about.
So I would say that that is common practice for an investigating officer to investigate all parties concerned about a complaint. And the role of the IO is then to prepare a report which has all of the information in it, no conclusions, no recommendations, just a gathering of the facts, which includes actually in the reports all the unredacted witness statements for the deciding officer to consider to allow them to come to a view.
Okay.
So it's very common for investigating officers to investigate the whole situation, if you like.
Okay, so you were compiling a factual report, or based on witness accounts, and presenting that to the Permanent Secretary. Can I ask what type of information was made available to Mr. Salmond and when?
So on the 7th of March, I think as was mentioned earlier, Permanent Secretary wrote to Mr. Salmond v's lawyers and included what are known as causes for concern, which were details of certain issues that she was asking him to provide a response to.
Okay, thank you. I also seen from my papers and what I've read and evidence thus far, Ms Mackinnon, that there was some consideration given to the investigation process being an independent process. I wonder if you can confirm if that was indeed the case, and why an independent process at the end of the day wasn't pursued.
So I think this was something that came up early doors in the development of the procedure, and the suggestion that an independent IO was raised. I think in my evidence last time, though, what I talked about there was the kind of standard process that we already have in Scottish Government for investigating matters like formal complaints. We've got a pool of investigating officers who tend to be, who are identified and trained, and we ensure that if they are investigating something, it's not something that they've been previously involved with. It tends not to be in their own business area, so that they have that independence.
Okay.
So this was an approach that's already embedded within Scottish Government, and that was certainly what was in my mind in the early stages of the procedure being developed.
Okay. And the procedure has no time scale attached to it. Do you consider that an omission?
No time scale in respect of
the complaints procedure, or are you working to timescales?
Well, timescales in relation to what? How long the procedure, the investigation will take, or?
Well, there's various.
What do you mean by
that? There are various stages and processes involved in an investigation. Is it in order for an investigation to go on for as long as it takes, or is there some I'm asking you about your processes and your procedures. I can't find timescales. Is there timescales?
No.
There's no timescales.
No.
Okay, and you don't consider that an omission or problematic in any way? I'm just asking your opinion. You're someone with an HR background.
We certainly have timescales in other procedures that we have. It's not always easy to stick with them, and in my experience investigating matters, you never really know what's going to come out of an investigation, and what we are required to do is conduct a full and fair investigation. And until you start to hear from people and start to understand the number of witnesses, etc., it's hard to say how long it would take. But what we are required to do is to ensure that we do it timeously and without delay, if possible.
Okay, and my final question, Convener, and thank you for your forbearance, is Ms Mackinnon, I wonder if you could just confirm the contact, or if you had contact with Miss Russell, the confidant, and if you had contact, whether that was before the complaints process kicked off or after, or both?
I had both. I spoke with Gillian beforehand, and I think I provided her with a bit of a framework to help her when staff were engaging with her, and then afterwards when she passed over certain things to us to deal with.
Okay, and a very quick supplementary to that. Where are the bounds of confidentiality here, bearing in mind the role of the confidant is to be a private sounding board, separate from the organisation, separate from HR? Where are the boundaries?
Well, they're very, very clear boundaries, and it was for the confidant to, if the individual hadn't wanted the matter shared, then that would have been respected. Okay. So Gillian would not have shared anything with myself or Nikki without permission of the individual.
Okay, thank you. Thank you.
Jackie Bailey.
Thank you very much, Convener. There is a lot to get through there, so can I welcome Ms Mackinnon back to the committee. Can I just return to follow up something that you said in relation to the police? Can I ask you, was a copy of your investigation report offered to the police by the Permanent Secretary?
I don't know. I wasn't involved in that part of the process.
Okay, would you be surprised to hear if it was? Because my understanding is a senior police officer certainly told the criminal trial that Police Scotland didn't want to see a copy of your report because it could contaminate their investigation. You have no knowledge of that?
So, not at the time. I didn't know at the time that had been offered.
Okay, but you obviously have heard of it since. Did you think that was a wise move on the part of the Permanent Secretary?
I don't know. I can't answer that question.
Okay. Thank you anyway. You told us previously that you'd been very open about your involvement with the complainants in late 2017. So I'm curious to know, why did the Permanent Secretary and Lord Advocate claim that it was only during the commission of documents in December that they decided to throw in the towel at all? Had you not told them the full extent of your involvement?
So, as I said previously, I was upfront about the contact at the time and during the process. My understanding about the judicial review decision related to our ability to evidence fully what that contact had been. So prior to December, I think I had provided everything that was asked for, and it was considerable, and it included the substantial meeting with Ms E, or the substantive meeting with Ms E on the 5th of December, and all the contact and emails in relation to that in the December. The outstanding thing... Sorry,
you carry on.
The outstanding things that came up as a result of the very specific information specification on the 17th of December, identified other places that we were expected to look for in terms of evidence.
Okay, so
and that's where...
Yeah. What you're telling me is that you were open and transparent about this since late 2017. Everybody knew about it. But for the judicial review, the process you went through was about providing the evidence to show that you knew about it. Okay, that's fine. So in December 2017, I think you told us before, you had meetings in person or by phone with the complainants. You and Miss Richards told them that you would be the investigating officer. I think you confirmed that to me after. In November, you had sight of what was later to become a complaint from Miss A, and the emerging policy was shared with one of the complainers. All of that was before the policy was adopted, wasn't it?
Before it was approved, yes.
Okay.
It was approved on the 20th of December.
So I'm kind of curious, given all of that brought together, why you told us you were shocked that the judicial review had been conceded. I mean, you recognise now that that conduct probably would be seen as incompatible with being an impartial investigator?
I was shocked about the judicial review decision because I felt I had already provided the majority of information that illustrated the level of prior contact, and that had been done in the November. And our organisational position was still, at that point, these things were inserted into the pleadings, and our organisational position was to continue to defend the action. And so, for me, the finding of felt to me relatively minor aspects of evidence, or in one case not really being able to evidence that at all in relation to a particular meeting, felt like that's why I was so shocked that those things, those relatively small things, admittedly in my view, had resulted in the concession.
I think your prior involvement, which was substantial, as you yourself acknowledge quite openly, showed a degree of partiality that, small though it may be to you, allowed the Court of Session to arrive at a judgment had it gone to full term, but for the Scottish Government to concede before that happened, because they understood they would lose the case on that basis. That's not really a small thing, is it?
That's not what I meant about a small thing. Really, what I was indicating there was that the bulk of the information about prior contact had already been passed over and was contained within the pleadings. Okay. And at that point, you know, the other side were very clearly stating the bias point. So the final information that was uncovered and passed over, you know, it was evidence of administrative aspects of the prior contact and nothing more than that. And I think that's why it was such a shock.
Okay. The Permanent Secretary gave us an impression in her earlier evidence that she wasn't really involved at all in the development of the policy. Isn't it the case that you and Miss Richards briefed her almost every step of the way? So she knew the role you played during your time as the investigating officer and prior to it?
The Permanent Secretary was briefed on the prior contact, and once the investigation got underway, I certainly wasn't in regular contact with her at all. I had one meeting with her to give her the interim report. But that was the extent of the engagement. So
was Miss Richards briefing her then on the development
Miss
of
Richards
the policy?
Well, she would be keeping the PermSec abreast of what she needed to know. She was in regular contact with her about a whole variety of things.
Can you remind me when you were appointed as the investigating officer?
So officially that would have been the 16th of January, 2018.
Okay, so can I ask then, there is apparently a OneNote from the 9th of January from you, where you talk about changing position of a potential complainer. You talk about better to get policy finalised and approved before a complaint comes in. There's mention of Miss Richards updating the Permanent Secretary and of not telling the former First Minister until you were ready. All of that was before you were appointed, wasn't it?
Before I was officially appointed, yes.
Oh, okay. Is that compatible with being an impartial investigating officer? Maybe that's a rhetorical question. As
I mentioned earlier, in December, in discussions with Nikki, we had decided I would likely be the IO, and we were progressing on that basis. Formal appointment on the 16th of January was as a result of a formal complaint coming in and the start of that investigation process.
Okay. Can I take us on to the conduct of the investigation? After your report was concluded, did you keep in touch with the complainers?
Yes. So I had provided them with regular updates on the progress of the situation as it developed until the point. So I think, as I mentioned earlier, at the end of July 18, beginning of August, I handed that over to Nikki Richards for 3 weeks because I went on leave. And then when I returned from leave, she handed that engagement back to me, and I continued to update the complainers on progress.
Okay. The committee is likely to have the legal advice provided to the former First Minister by Levian McRae, because my understanding is he's waived legal privilege. Did you share any of the information about the positions taken by Levian McRae provided to you with the complainants?
No, I didn't share legal advice or any documents from Levian McRae. I really just updated the individuals with progress, you know, as it would affect them. So, for example, the initial delay in a response from the former First Minister, the initial time frame that was provided by the Permanent Secretary was not to be met, so I let them know there's no response to the Permanent Secretary's letter for another however long, 2 weeks or whatever it was. So that was the kind of updates I was providing.
Okay, I'm clear from what you've just told me you didn't share documents, but did you summarise the contents of documents and share them with complainants? Or indeed witnesses, for that matter?
No, I wouldn't say I summarised documents. I would be making them aware of what they needed to know as it would have affected them.
So in that context, what I'm trying to get at is, did you share any information pertaining to the legal position advanced by Levian McRae on behalf of their client with any of the complainants or witnesses, whether it's summary version or otherwise?
So I think I need to check the specific documents, my specific updates, if you don't mind.
Okay, I'd be happy if you did that.
I would rather do that.
It would be very helpful if we don't receive the updates in the tranche of documents we're due to get, whether you could do us the benefit of providing them to us. Can I move on quickly to the judicial review, started in August 2018. You told us previously that it was your job to report developments to the complainants. Who gave you that task?
That would have been agreed with Nikki Richards.
Okay, and did she get asked to do it by somebody else? Do you know? Don't worry, we can ask.
I don't know.
Okay, that's fine. You told us that the meetings for the judicial review last time were 3 times a week. I think Mr. Coquette said it was almost daily. Whatever the frequency, I am genuinely surprised, understanding how the civil service like to record things, that there doesn't appear to be a minute, a OneNote, anything of those meetings. Did you record those meetings?
I didn't record them. I took my own actions away from them. And which effectively was updating the complainers. So I suppose my record of those meetings would be the update emails that went to the complainers.
Fine, and we're going to get a copy of those, so that's very helpful. We heard from Mr. Coquette about the prospects of sisting, which is postponing the judicial review, and the Lord Advocate also mentioned it in his evidence a couple of weeks ago. You were aware of that possibility, weren't you?
Of sisting the judicial review?
Yes.
I am not sure that I was.
Could you maybe check that?
Sure.
Because I'd be curious to know whether you informed any of the complainants or anyone else that the Lord Advocate was considering the prospects of attempting to assist the judicial review behind the criminal case. Okay, so that would be very, very helpful. Finally, when you were giving evidence under oath to the Commission on documents, were you transparent about the extent of your contact with Miss A and Miss B before you were appointed investigating officer?
In the Commission on Diligence?
Yeah, it was the Commission on
Is that what you're referring to?
Yes.
I
mean, did you tell them about the extent of your contact?
So my recollection is that they were asking me, so and I'd never been involved in anything like this before, so it was very much about documentation, and it was very much about referring me to documents that I had provided and checking with me whether they were further documents in relation to it. So, for example, if a document said in it, as per our conversation or from our meeting, they were asking, is there a record of that conversation or that meeting? Could you go and check if there is? So that was the kind of the basis for the whole session. It was really about the documentation that was there, so referring to, and all the documents had already been provided about the bulk of the prior contact. The one thing that I and I did leave the Commission with a commitment to go and do further searches, because things like, for example, the meeting on the 16th of January, I didn't have a record of it, and I couldn't find a record of it, and they asked me again to go and check if I could do that. So that was the main purpose of the Commission on Diligence.
Okay, thank you very much.
Alex Cole-Hamilton, I understand, has a short supplementary.
Thank you very much for bringing me back in, Convener. Ms Mackinnon, in answer to me earlier, when I asked you if when those complaints first came, or the concerns first came to light before they were made formal, if you had suggested that the complainers hang fire, if either you or anyone else had suggested they hang fire until there was a policy, to which you said no, and I understand that and accept it. But at that time, they were given a draft policy to look at, to sense check and to see if it might have helped their situation. Was that not in and of itself an indication that there was a policy coming down the tracks that would address their complaints and as such might induce them to hang fire from making their complaint formal?
We certainly were open with them about the fact that there was a policy underway. And you're right, we shared a draft, and they knew it was a draft. And so, I mean, that's the facts of the matter. It wasn't about inducing them to do anything. It was just about, as part of normal process, to share with individuals considering making a formal complaint what a process might look like and what to expect as someone who would be involved in that process.
But I imagine you would have told them how advanced that policy was, and the effect of that might have been that they will say, well, in which case, we'll just wait a couple of weeks until this is signed off.
Certainly never had a conversation like that with any of them, and it was left to the individuals for them to come back and say that they wanted to make a formal complaint.
And final question, Convener, if I may. I asked you about who knew of the complaints, the existence of the complaints, and you gave a very defined list of government officials, including yourself, Nicola Richards, Barbara Allison. But we now know that John Summers, the First Minister's private secretary, met with a complainer on 2 occasions, I believe on the 20th and 21st of November. When did you first learn of those meetings, and what was his involvement in terms of liaising with those officials who were in the loop, as it were?
I had no knowledge at the time that had happened, and actually I have only discovered those meetings through the preparation for this inquiry.
Really? Okay. So you're telling me that the First Minister's most senior civil servant who is attached to her office received a disclosure but to your knowledge did nothing with it within the upper reaches of the civil service at that time.
Well, I'm saying I didn't know about it.
But you were the investigating
Personally,
officer.
that's all I can say.
Yeah.
Well, but I was investigating officer in when things kicked off in January. I didn't know that those meetings were happening at the time, and I only found out much, much later that they had taken place.
Okay, thank you. No further questions.
Andy Whiteman.
Thank you very much, Convener. Good morning, Ms Mackinnon. Either in your opening remarks or in response to an earlier question, you said that following the November 2017 email from the Permanent Secretary to all staff, people came forward. Can you tell me roughly how many people came forward? Was it a handful? Was it tens?
I think there was about 10 or 11 people.
Okay. And how many of those, to your knowledge, were concerned with matters that were complaints against the former First Minister?
So I'm just pausing in terms of the jigsaw identification. So if you don't mind, I would like to come back and clarify that for you.
Okay, that's fine, no problem. So one complainer came forward in mid-December, and if I can draw your attention to, I think it's document YY050, which is an email of the 14th of December from Nicola Richards to Ms A, copying yourself and Nicola Richards into it. And it describes a number of options available to the complainer. It says that you're going to, sorry, Nicky Richards will be on leave, returning on the 9th of January, but Judith is very happy to be contacted if you want to talk at any time. None of those options include the possibility of a complaint under the Fairness at Work policy. Was that intentional?
I imagine it would have been intentional in terms of the appropriateness of Fairness at Work policy and the subject matter that was being raised.
So in your view, because we heard from James Hind on the 25th of August that the Fairness at Work policy had a gap that he had identified in relationship to former ministers. But we also heard from Nicola Richards on the 25th of August, and I quote from her evidence, that complaints about third parties, which is in essence what a minister or former minister would be in this instance, are a fairly routine part of other policies and are included in our Fairness at Work policy. So I just want to know, had the complainer wished to complain under the Fairness of Work policy, would it have been admissible, given that it was a complaint about a former First Minister, even though there wasn't a specific procedure for that?
I would have said no. The Fairness at Work policy allows for complaints against current ministers, but not former. And that's where the gap that James Hind had identified and the HR team had also identified, that was a gap in our existing processes. Okay,
thanks. I just want to move on to the question of prior contact, because this same email from Nicola Richards says that in the case of it being a formal process, then it's likely that Judith would take the role of the senior officer, given she had no involvement at the time and her professional experience. Is it your understanding that the phrase "no involvement at the time" relates to any involvement involvement that you did not have when the alleged incident took place many years earlier?
That's correct.
Okay, thanks. That's helpful. Can I move on to the question, therefore, of prior contact? In general terms, in your understanding of the term prior contact, did prior contact have the same meaning as no involvement at the time?
So I think they're two different things. Prior involvement in the matter being investigated and prior contact with the individuals in terms of process, I think are two different things.
Okay, so no involvement at the time is clear, but prior contact with the complainers, how far back would prior contact have to be for there to have been no prior contact?
Well, I'm not quite sure what you mean by that.
Well, I'm just wondering because during your previous evidence session, you stated that the initial drafting of the procedure, the initial drafting, I'm quoting here, the initial drafting was very clear about the prior contact that could take place, and that is how I operated. So what was your understanding, therefore? Because it says the initial drafting was very clear about the prior contact that could take place, and that's how I operated. So what was your understanding of prior contact?
So my understanding was exactly what I did, you know, making sure that the individuals were aware of the options open to them and what the process might look like should they decide to make that formal their concern a formal complaint. So, and I think I'd said previously that's why I felt I was acting in completely in line with the policy, albeit that earlier revised version of it.
Okay, that's helpful. Thank you very much. Could I move just forward to the point in time, I think in March 2018, when the former First Minister became aware of the nature of a formal complaint having been made against him. I think from what you said earlier that it was the Permanent Secretary who made the former First Minister aware that a complaint had been made. Is that correct?
She wrote to him through his lawyers, I understand, yeah.
Okay. And the First Minister's lawyers then corresponded with the Permanent Secretary, and there's quite extensive correspondence. How much of that correspondence was shared with you, broadly speaking?
I saw correspondence that was anything relating to the investigation or anything that I had to update the complainers on. Okay,
so for example, when the extent to which witnesses were suggested by the former First Minister and the extent to which any witnesses were asked questions that he considered relevant, those kind of points would be drawn to your attention because presumably only you would know the answer to those questions.
Yes, so I would notify the complainers that, for example, you know, the former First Minister has put forward witnesses for me to interview, and that will take place over the coming weeks. So just so you know, that's what's happening just now. I am now investigating and speaking to other witnesses put forward by the former First Minister.
Okay, and you did indeed speak to all those witnesses, did you?
I spoke to 4 of them, and I received a statement from a 5th one, and the former First Minister himself provided a statement. Okay,
and that was all then wrapped up in your draft report that you sent to the Permanent Secretary. That's fine, thanks.
That was the final report that went to the Permanent Secretary.
Yep, thanks. What do you understand of what's the relationship between your role as investigating officer and the role of the confidant?
Completely separate. The confidant role was very much at the earlier stages of the process for people coming forward. However, one of the things that, so my role with the complainers on an ongoing basis was to ensure they were aware of progress and developments. I wasn't providing pastoral or emotional support, but I was giving them options where they could access that type of support. and those options included the previous confidant role in Gillian Russell. But there was also other options in terms of, you know, external counselling support, for example.
And the role of the confidant, has that always been part of Scottish Government procedures as far as you can remember?
I don't think so, and I was really quite new into the organisation at that point. I only joined in August 17. I do think that the confidant role was introduced in particular in relation to this process, and that's the role that Gillian took on. However, I think that she's still identified within the organisation as someone that people can go to, so it's still an option that's there for staff.
Okay, thank you, Convener.
Thank you. I've just got a couple of questions to wind up with, Ms Mackinnon, if you would. In the Permanent Secretary's, or one of the Permanent Secretary's letters to Levy and McRae, included details of anonymous complaints. And I'm just wondering whether you investigated any anonymous complaints.
Was she not referring to the two individuals who had made the actual complaints? Because their names were not shared at that stage with the FFM.
So you don't think there was anyone beyond that then?
I don't think so. I'd have to go and check, but I'm sure it would just be the two complainers who had asked for their names to be kept anonymous.
Okay, thank you. And talking about the complainers, I wonder if either of them ever expressed a view to you and the extent of the independence of the policy or the process as it was going forward.
Not to me, they didn't.
So
no.
You felt they were confident with it?
They certainly didn't say they weren't.
Right.
They didn't express that view.
Okay, thank you. The last thing I wanted to ask you is back to the beginning of this session when we were talking about discussions with the police, and you were quite upfront when you said as an HR professional that there was a reluctance of the two complainers to go to the police, and you were asked to sound them out by Nicky Richards. Can I ask you, as I say, in your view as an HR professional, when people are raising complaints of a serious nature like this, is it generally the case that people would have, when I say encouraged, I don't mean that in a bad way, I mean it, people have to be given the confidence to either go to the police themselves or to agree to allow their employer to go to the police. Would that be the case generally?
Yes, generally, absolutely. Individuals have always got the opportunity or the option to raise a complaint. If someone, they've always got that opportunity to make a complaint at any stage.
Yeah, but actually going to the police about it, is that something that understandably people would be reluctant to do?
I can't imagine it would be an easy thing to do. At all. I can't speak for the individuals, but I can't imagine for 1 minute it would be an easy thing to do.
And do you think there's any particular obligation on an employer to encourage people to do so?
Well, I think as the policy states that, that the Scottish Government may consider making a referral to the police if they consider that there's potentially something criminal has happened. And that's exactly what happened in the end. But I think that before that decision was made, there was obviously considerable information and facts gathered about the complainers' experience, and with all the evidence that was finally produced for the deciding officer's report, that decision was obviously felt to be the right one.
Okay, thank you very much. I think that's all our questions. Thank you very much for coming with your evidence today and for the time you have given to us. And we'll now have a short break of a few